I'm Josie. I'm 33. And 4 weeks before my sister's wedding, my mother texted me a single line that ended 11 years of pretending our family didn't have an asterisk next to my name. I crossed you off the final list. You're not really family, Josie, not the way this day needs. I hope you understand. I want to tell you what happened between that text and the day I stood in a courthouse hallway holding a folder that proved, in my grandfather's own handwriting, exactly how wrong she was. It involves an orchard my grandfather spent 50 years building, a trust he rewrote 2 months before he died, a forged affidavit with my brother's signature on it, and a family who thought blood was the only word that mattered until the paperwork said otherwise. Welcome back to Sweet Payback Stories, where the people who get written out are usually the ones who end up holding the pen. If you've ever been told you weren't really family, stay with me until the end. Drop a comment and let me know you're here. My parents, Carol and Robert Marsh, adopted me when I was 9 days old, after years of trying and failing to conceive. 2 years later, to everyone's genuine surprise, my mother got pregnant with my brother Nathan. 3 years after that came my sister Brooke. Growing up, nobody hid that I was adopted. It was simply a fact, stated plainly at the right age, folded into family stories the way facts get folded in when nobody's decided yet whether they matter. For most of my childhood, I don't think they did. It was only later, somewhere in my 20s, that I started noticing the small, specific gap between how family got used for me and how it got used for Nathan and Brooke. I work in marketing now, but I grew up, every summer at Marsh Family Orchards, 60 acres my grandfather Gerald planted in 1974, cider press older than my mother, a farm stand he ran himself until his hands got too unsteady to make correct change. Gerald never once made the distinction the rest of the family quietly made. To him, I was simply his granddaughter, full stop, and some of my clearest childhood memories are of him teaching me to graft apple branches, while Nathan, 3 years younger and less interested, played in the dirt nearby. When Gerald died 2 years ago, I inherited, informally, the job of organizing his business archives, decades of ledgers, correspondence, and records nobody else in the family had the patience or the interest to touch. There's a particular kind of love that shows up in small, repeated actions rather than grand declarations, and Gerald's love for me was almost entirely built out of those. He was the one who showed up to my college graduation 2 hours early, with a folding chair from his truck bed because he didn't trust the venue's seating. He was the one who called every single one of my birthdays at exactly 9 and 1. The morning, never a text, always a call, because he said texts didn't count for the things that mattered. My mother loved me too, in her way. I want to be fair about that, even now, but her love always seemed to come with a faint asterisk attached, a small qualifying clause I could feel more than name, right up until the day it stopped being subtle at all. The trouble started, as trouble in families usually does, with a group chat. Brooke's wedding to her fiancé Patrick was set for late September, and the planning chat, Brooke's big day, filled up fast with vendor links and color swatches. I offered, genuinely excited, to have the Orchard Cidery do the signature cocktail using Grandpa's original spice cider recipe, something I thought would mean something to everyone, given where we'd all spent every childhood September of our lives. My mother replied within the hour, "Oh, that's sweet, but Patrick's family already has a caterer with it. A full bar package, it's easier to keep it all under one vendor." I understood on its face. What I didn't understand until I looked closer at the thread later that week was that she'd said yes to a signature cocktail idea from Nathan's wife 2 days earlier, a bourbon flight from a distillery Nathan's father-in-law happened to own. I told myself it was a coincidence. I told myself a lot of things were coincidences by that point in my life. I brought it up once lightly at Sunday dinner, framing it as a joke rather than a complaint, the way I'd learned to frame most things in that house. Guess the Marsh cider tradition lost out to Bergen this year. My mother laughed, a little too brightly, and said, "Don't be so sensitive, Josie. It's Brooke's Day, not a referendum on the orchard." Nathan didn't look up from his plate. Brooke gave me a small, apologetic smile that told me she'd noticed too, even if she wasn't going to say anything about it at her own engagement dinner. A few weeks later, I noticed something odd on the orchard's shared calendar, which I still managed as part of sorting Gerald's records. 3 meetings, marked simply family business, estate, scheduled with a law firm I didn't recognize, none of them including me, all of them including my mother and Nathan. I asked Nathan directly what they were about. He said, a little too quickly, just some formalities, cleaning up Grandpa's paperwork, nothing that needs your attention right now. I asked my mother the same question separately. She gave me almost the identical phrase, just formalities, which struck me, even then, as an oddly rehearsed thing for 2 people to say independently, unless they'd rehearsed it together. I let it sit for a few days, then tried a different approach, asking Hal casually during one of our irrigation checks whether he knew anything about a law firm visiting the property. He said seen an unfamiliar car in the lot twice that month, plates from 2 counties over, parked near the office rather than the farm stand. Didn't think much of it, he said. Figured it was insurance folks. I didn't correct him. I didn't yet have anything solid enough to correct him with. I just filed the detail away, the way I'd started filing away a lot of small details that spring, the way you do when a pattern is forming faster than the evidence for it. At Brooke's dress fitting a week later, standing in a boutique dressing room while my sister turned in front of 3 mirrors, I mentioned gently that I'd love to help coordinate the orchard's contribution to the rehearsal dinner, since Grandpa had loved Brooke so much, and it felt like a way to include him. My mother, without looking up from the veil she was adjusting, said, Josie, this is a marsh blood tradition kind of moment. Let's not make it complicated. Specific way rooms go quiet when everyone heard the same thing, and nobody wants to be the one who says so out loud. Brooke caught my eye in the mirror for half a second, then looked away. Nobody corrected our mother. I didn't either that day. The seamstress, a stranger to all of it, filled the silence the way strangers sometimes do, asking brightly whether I was the maid of honor. My mother answered before I could. Oh no, that's Nathan's wife, Josie's just. She'll be a guest. I stood there holding a box of veil pins I'd been asked to hand over, watching my mother describe my role in my own sister's wedding in 4 words that took less time to say than it takes to tie a bow. Brooke apologized to me quietly in the parking lot afterward, said Mom hadn't meant it the way it sounded. I told her I believed she believed that. I told her I wasn't sure I did anymore. In the weeks after that, I noticed I'd stopped being looped into things by degrees so small I could almost convince myself I was imagining it. A vendor walkthrough I heard about after the fact, a close family-only engagement photo session at the orchard that somehow didn't include me despite being held on my own family's land. I texted my mother asking, plainly, if I was still invited to the rehearsal dinner. She replied, of course, don't be dramatic, which wasn't actually an answer to the question I'd asked. I stopped asking direct questions after that. I'd learned over enough years that direct questions only ever got me indirect answers, and indirect answers hurt in a slower, more corrosive way than a clean no ever would have. I threw myself into the orchard's archive project instead, the way I've always thrown myself into work whenever home starts feeling like a place I have to brace for rather than return to. I spent 3 straight weekends alone in Gerald's old office, cataloging decades of receipts and correspondence, telling myself it was simply overdue organizational work and not in any way an excuse to be somewhere that had never once made me feel like a footnote. Hal brought me coffee most Saturdays without being asked, sat with me for a few minutes, never pushed for conversation I didn't offer. It was, that whole stretch, the steadiest company I had. That same month, going through Gerald's old office at the orchard to finish an archiving project I'd been chipping away at for a year, I found a sealed envelope tucked behind a filing cabinet, already opened, addressed in his attorney's letterhead. Remended Succession, Marsh Family Orchards Trust. Inside was a full copy of a trust amendment dated 2 months before Gerald died, naming me, not Nathan, not jointly among the 3 of us, as majority successor and operating trustee of the orchard, with Nathan and Brooke retaining equal financial interest, but no operational control unless I chose to grant it. Attached to the amendment was a short handwritten note in Gerald's shaking, late-in-life script. Josie, you're the one who shows up. Always have been. Land needs someone who will actually walk it, not just inherit it. Love you, kid. Don't let anyone make you feel like you have to earn what's already yours. I sat on the floor of his old office a long time with that note in my hands, understanding, for the first time, exactly how deliberately my grandfather had tried to protect me from something he must have seen coming long before I did. I called Priya's name in my head before I'd even met her, some instinct telling me this document needed a lawyer's eyes eventually, though it would be weeks before I actually made that call. That first night, though, I just sat with it, reading the amendment's dense legal language 3 or 4 times over, translating it slowly into plain English in my head. Majority successor. Operating trustee. My name, typed cleanly next to those 2 phrases. In a document my grandfather had walked into an attorney's office and signed 2 months before he died, fully aware, fully deliberate, choosing me in a way no one in my family had ever chosen me quite that plainly before. I drove home that night lighter than I'd felt in months. My grandfather, the one person in this family who'd never once made me feel like an asterisk, had looked at all 3 of his grandchildren and decided, in his own words on paper, permanently, that I was the one who showed up. It didn't erase the dress-fitting comment or the quietly excluded photo session, but it gave me something solid to stand on that neither of those things could touch. For the first time since Gerald's funeral, I let myself believe the orchard's future, and maybe my place in this family might actually be safer than it felt. I drove out to the orchard the next morning before my day job, just to stand in the rows he'd planted, the note folded carefully in my jacket pocket, like something that might dissolve if I handled it too roughly. Hal found me there around 7, and I ended up showing him the note, unable to keep it entirely to myself. He read it slowly, then nodded once, unsurprised in a way that told me he'd probably known more than he'd ever let on. "Your grandpa talked to me about this, you know," he said. "Not the details, just told me, a few months before he'd passed, that he'd finally put something on paper that said what he actually meant, instead of what everyone assumed he meant. Didn't say your name, didn't have to. I already knew who he was talking about." That hope lasted 11 days. Hal Whitcomb, the orchard's longtime manager, had worked alongside my grandfather for 30 years, and had known me since I was small enough to ride on the tractor fender. Over coffee one morning, checking irrigation lines together, he mentioned, carefully, that Carol and Nathan had been meeting with a different attorney. Not the family's longtime firm, but a new one specializing, Hal had heard, in trust litigation. "Didn't want to be the one to tell you," he said, "that you should hear it from someone who's on your side before you hear it from someone who isn't." According to what he'd picked up, they were exploring a challenge to the amendment itself, built around a claim that Gerald hadn't been of sound enough mind in his final months to have understood what he was signing. I asked Hal how confident he was in what he'd heard. He said confident enough that he'd started keeping his own informal notes, dates, overheard fragments, anything he thought might matter someday, just in case somebody ever needed a witness who wasn't inside the family, and didn't have a horse in the race. I thanked him and meant it more than the words, probably conveyed because in that moment I understood I had exactly one person in this entire situation whose account of things I could trust without having to second-guess the motive behind it. I spent the next week learning more than I ever wanted to know about the beverage industry's interest in small regional orchards. A company called Highfield Beverage Group had approached the family twice in the past year with a buyout offer for the land and the cidery brand, a serious number, enough to change every one of our lives financially, contingent entirely on a clean, uncontested ownership structure they could negotiate with quickly. Nathan, I learned from a mutual friend who worked in local agriculture circles, had been in informal talks with Highfield's regional rep for months, well before Gerald's amendment had ever surfaced publicly within the family. If the succession structure Gerald had actually written could be quietly replaced with something more evenly split, or more easily controlled by Nathan and my mother, a fast, clean sale became a real possibility. My grandfather's 60 acres had turned, without my noticing exactly when, into a deadline. I pulled up Highfield's public filings that weekend, the kind anyone can access if they know where to look, and found their regional expansion plan explicitly listed underutilized family-owned orchard properties as acquisition targets, with a note about streamlined ownership transitions as a key negotiating priority. Reading that phrase, sitting at my own kitchen table, I understood exactly what Nathan's informal talks with their rep had probably actually been about. not just curiosity, but active positioning, months in advance, for an ownership structure that hadn't existed yet, built around an assumption that my grandfather's actual wishes were simply an obstacle to be quietly worked around, rather than a decision that had already been made. The text arrived on a Tuesday evening, 4 weeks before the wedding, the same week I'd finally asked my mother, directly over the phone, what exactly the estate meetings were about. She deflected again. An hour later, my phone buzzed with her message. "I crossed you off the final list. You're not really family, Josie, not the way this day needs. I hope you understand." I read it standing in my kitchen, the same room where I'd once told myself the dress-fitting comment was probably nothing. I understood, reading it a second and third time, that this wasn't really about the wedding at all. It had arrived 4 days after I'd started asking pointed questions about the estate meetings, and I recognized, with a clarity that made my hands go cold, that my mother wasn't disowning me over seating charts. She was disowning me over a trust she was trying to unravel, and the wedding guest list had simply become the most convenient place to do it in writing. I sat with my phone in my hand for a long time that evening, rereading the message until the words stopped looking like words and started looking like shapes. I thought about calling her immediately, demanding an explanation on the spot, the way some earlier version of me might have. Instead, I set the phone face down on the counter and made tea I didn't end up drinking because I understood, even in that first raw hour, that whatever I said back to her needed to come from somewhere steadier than the version of me reading that text for the 4th time. I didn't respond that night. I let the silence sit exactly as long as her silence about the estate meetings had sat with me. I called a trust and estate attorney the next morning, a woman named Priya Sandoval, recommended by a colleague who'd handled something similar for her own blended family. I told her everything: the amendment, Hal's warning, Highfield's interest, She was quiet a moment, then said the sentence that changed how I understood my footing in all of it. Adopted heirs have the exact same inheritance rights as biological ones under state law, full stop. That's settled, not up for family debate, and a validly executed trust amendment isn't overturned by "we think he seemed a little off sometimes." They'd need real documented evidence of incapacity or undue influence, not just a preference for a different outcome. I'd spent years quietly absorbing the idea that my place in this family was somehow softer, more provisional than everyone else's. For the first time, a professional who had no emotional stake in any of it was telling me, plainly, that the law had never agreed with that idea in the first place. Priya asked me to bring in everything: the amendment, Gerald's note, Hal's account, screenshots of the text. I spent an evening compiling it into a single folder, and somewhere in the middle of that quiet, methodical work, I noticed my hands had stopped shaking for the first time in days. There was something steadying about turning a feeling that had lived in my chest for years into a stack of dated, factual documents that didn't require anyone's interpretation to be believed. "You've actually got an unusually clean record here," Priya told me, flipping through it. "Most people come to me with feelings and fragments. You came with a paper trail. That's going to matter." Priya laid out my choices without softening them. I could let the wedding exclusion stand, avoid escalating anything, and simply wait to see whether the challenge to the trust actually went anywhere. I could call my mother directly and ask her to explain herself fully, one more time before anything became formal. Or I could have Priya send a preemptive notice affirming the amendment's validity, which would guarantee, immediately and permanently, that this stopped being a family disagreement we could later pretend had never happened. I thought about Gerald's handwriting. "Don't let anyone make you feel like you have to earn what's already yours." I thought about the text still sitting, unanswered, in my phone. I understood, sitting in my car outside Priya's office, that whichever path I chose, there was no longer a version of this family where I could go back to simply hoping things would quietly get better on their own. I called Brooke that same week, not to tell her everything yet, but to ask, gently, whether she was okay, sensing she was as caught in the middle of this as anyone. She said she was fine too brightly, the way people say fine when they mean the opposite and aren't ready to say so. I didn't push. I understood, better than most people could have, exactly how much weight a person can carry silently before they're ready to set any of it down, and I wasn't going to be the one to force that moment before she was ready for it, 10 days before her wedding, no matter how much I needed an ally. I chose to act, and Priya sent the notice within the week, a formal letter to my mother, to Nathan, and to their new attorney, affirming the amendment's validity, requesting immediate disclosure of any challenge already in preparation, and reminding all parties, in the flat, unemotional language lawyers use, that fabricating grounds for a trust contest carries real legal consequences. I didn't call my mother first. I let the letter say what 4 years of indirect answers had never let me say clearly myself. She called me 3 days later, her voice tighter than I'd ever heard it. "Josie, what is this? Are you suing your own mother a month before your sister's wedding?" I told her, calmly, that I was simply protecting a legal document her father had signed with full capacity and full intention, and asked her, since we were already talking, what evidence exactly her attorney believed they had. She didn't answer that part. She never did, that whole call. She called back twice more over the following days, each time circling the same ground without ever quite landing on a real answer. The second call, she tried a softer approach. "Can't we just talk about this like a family, without lawyers involved?" I told her I would have loved nothing more than exactly that. Weeks earlier, before a text calling me not really family had already made the terms of this conversation for both of us. She was quiet for a long moment, then said she had to go, and I let her go, because I'd stopped expecting that particular silence to turn into anything different. The answer came a week later, indirectly, the way most things in this story arrived. Not from my mother, but from a paralegal at the new firm who mistakenly copied me on an internal email meant for Nathan, containing a draft petition. Standing at my own kitchen counter, I found the actual claim for the first time, a petition to invalidate the amendment based on diminished testamentary capacity, supported by an attached medical letter suggesting Gerald had shown signs of cognitive decline in the final months of his life. I pulled Gerald's actual medical records the same afternoon, records I had legal standing to request as a named trustee, and found something the petition conveniently hadn't mentioned, a cognitive assessment performed by his own physician 3 weeks before he signed the amendment, scoring him in the normal range with a note reading, in the doctor's own words, "Patient remains sharp, articulate, and fully oriented. Discussed complex estate matters with clear understanding." Someone had built a legal challenge on a medical claim that Gerald's own doctor had already formally contradicted in writing. I sat with both documents open side by side on my kitchen table that night, the fabricated concern about his decline on one side, his actual doctor's plain, dated assessment on the other, and felt something in me shift from hurt into something more focused. Priya, when I sent her both, was quiet for a moment on the phone, then said, "This isn't a weak argument they're making, Josie. This is close to no argument at all, dressed up to look like one. That tells me something about how confident they actually are underneath it." I understood what she meant. A family that truly believed their case was solid wouldn't have needed to leave out the one piece of evidence that undid it. Digging further into the petition's attachments, I found something worse, a sworn affidavit from Nathan himself, stating he'd personally witnessed Gerald showing clear confusion during a visit to the orchard the week the amendment was signed. I remembered that particular week distinctly, because I remembered Nathan hadn't been in the state at all. A quick check of his own social media, flight photos, a tagged brewery, visit 3 states away, dated the exact days his affidavit claimed he'd been standing in Gerald's kitchen, and confirmed it. My brother had signed a notarized statement swearing to something he could not possibly have witnessed, because he had, provably, not been there. Priya brought in an investigator to formalize the timeline, mostly because she said a court would want more than a social media screenshot, even an obviously damning one. The investigator's report confirmed it cleanly. Nathan's flight records, hotel confirmation, and a credit card charge at the out-of-state brewery all placed him roughly 900 miles from the orchard on the date his affidavit claimed first-hand knowledge of Gerald's condition. The notarization itself had been done at the new attorney's office, same day, with no apparent effort made to verify the timeline against anything beyond Nathan's word. This wasn't a family exaggerating a grandfather's occasional forgetfulness anymore. This was a fabricated sworn statement, filed with an actual court, and the name attached to it was my brother's. I called Brooke, not Nathan, not my mother. Her wedding was 10 days away, and I hated adding this to her plate, but I needed one honest conversation with someone in this family before it went any further. She started crying almost immediately. I heard them arguing about the affidavit 2 weeks ago, she said. Nathan didn't want to sign it at first. Mom told him it was just a formality, that nobody would actually check, that it was for the family's future. Not really a lie, just helping things along. I should have called you the second I heard it. I told myself it wasn't my fight, that I just needed to get through my wedding without everything falling apart. I asked her whose idea the guest list text had really been. She was quiet a moment, then said, "Mom's, but I think it was about the trust stuff more than the wedding," even though she wouldn't have admitted that to either of us. Hearing my own sister confirm what I'd already suspected didn't make it easier. It just made it real in a way that a private theory hadn't quite managed to. "I keep thinking about what kind of maid of honor I'm going to look like," Brooke said, half laughing through the tears in that specific painful way people laugh at their own worst thoughts. "If my own sister isn't even at my wedding because of something I stayed quiet about." I told her that wasn't her responsibility to carry, that the choice had never actually been hers to make in the first place. She didn't fully believe me, not that night, but she thanked me for saying it anyway, and asked, in a small voice I hadn't heard from her since we were kids, whether I still wanted to come, whatever happened with the rest of it. I told her more than anything in the world. Priya sent a formal notice to my mother, Nathan, and their attorney, laying out the medical records contradiction, the fabricated affidavit, and the investigator's timeline findings, with a copy to the state bar regarding the notarization irregularities. The letter offered one path forward: full mediation, complete transparency, in place of pursuing a fraud referral against Nathan for the affidavit itself. It was framed as an offer. Everyone who read it understood it was also a line drawn firmly enough that nobody could pretend not to see it. My mother called 11 times over the following 3 days. I let most of them go to voicemail, not out of cruelty, but because I'd finally learned, watching this unfold, that answering immediately had never once gotten me an honest answer from her, only a faster, more polished version of whatever she'd already decided to say. Highfield Beverage Group's rep, according to Hal, quietly stopped returning Nathan's calls that same week, once word reached them that the ownership structure they'd been counting on was now the subject of a documented legal dispute rather than a quiet family handshake. Nathan texted me once during those 3 days, a single line. "Can we talk? Just us, no lawyers." I almost said yes immediately, some old instinct in me still wanting to protect him from whatever was coming. Then I remembered the flight confirmation with his own name on it, dated the exact days he'd sworn, under oath, to have been somewhere else entirely, and I told him I'd be glad to talk once the mediation was scheduled, with everyone present, so nothing that got said could later become another version of just formalities that only he and I remembered differently. Mediation happened 6 days before Brooke's wedding, in a conference room 3 floors above the county courthouse, which felt, walking in, like a strange place to be settling a family fight days before a wedding that was supposed to be the family's happiest moment of the year. My mother arrived pale, hands unsteady around a coffee she never touched. Nathan wouldn't look at me for the first half hour. Brooke wasn't required to be there, but she came anyway, sitting closest to me, which told its own story before anyone said a word. My mother reached first for the version where this had all been a misunderstanding, where the medical letter had simply been one doctor's opinion, not the whole picture. I asked her, evenly, whether Nathan's affidavit had also just been one opinion, given that he'd been 900 miles away on the date he swore, under oath, to have personally witnessed. She had no answer that survived being said out loud in that room. Nathan finally spoke, quietly, near the end. "I didn't think anyone would actually check a flight record, Josie. I know that's not an excuse. Mom said it was just paperwork, that it would smooth things over before they got messy." I should have said no the second she asked. The mediator, a calm man who'd clearly sat across from worse family disputes than ours, asked my mother directly what "not really family" had meant when she wrote it. She sat with that question a long time, longer than she'd sat with any question that whole meeting, and I watched her search for a version of the answer that wouldn't sound as bad out loud as it had in text. She never quite found one. What she landed on instead, eventually quietly, was closer to the truth than anything else she'd said all day, and it was the first moment in the entire meeting where the room actually went still. The mediator laid out the facts plainly, the way facts eventually get laid out once enough documentation exists to make denial impossible. The amendment was validly executed, supported by contemporaneous medical evidence of Gerald's full capacity. The challenge's central affidavit was demonstrably false. Any further attempt to contest the succession without new, legitimate evidence would expose the family to real legal and professional consequences, particularly for Nathan given the notarization issue. My mother, facing both the collapse challenge and her son's exposure, agreed to formally withdraw the petition and to a written acknowledgement, filed with the court, affirming the amendment's validity going forward. I didn't push for a fraud referral against Nathan, though Priya confirmed I had every right to. What I wanted most, sitting in that room, wasn't to watch my brother face criminal consequences days before our sister's wedding. It was simply for the truth to exist somewhere permanent, on the record, where it could never again be quietly rewritten into just formalities. The court filing that formally closed the challenge ran barely 2 pages. Clean and procedural, the kind of document that would mean nothing to a stranger reading it cold. To me, it meant everything. A permanent, dated record affirming that my grandfather had been of sound mind, that his amendment stood exactly as written, that no further challenge could be raised without new and legitimate grounds. Priya handed me my copy outside the courthouse afterward, and I stood there a moment in the parking lot just holding it, thinking about how strange it was that 2 pages of dry legal language could feel like the loudest, clearest thing anyone in my family had ever said about who I actually was to them. Carol's next sentence, once the paperwork part of that meeting ended, was the closest thing to an actual explanation I'd ever gotten from her. "I panicked," she said, not quite looking at me. "Your grandfather built something I always assumed would come to Nathan because he was the one who talked about running it, who fit the picture I'd always had in my head. When the amendment named you instead, some old part of me that I'm not proud of decided it must mean you weren't really." She stopped herself before finishing the sentence a second time, which told me she at least understood, finally, how it would have sounded out loud again. "I used the wedding to punish you for something that was never actually your fault. I know that now. It wasn't a full apology, not the kind that undoes a text like that in one sentence. But it was the first time in 33 years my mother had described her own thinking to me honestly, instead of managing how I received it, and in that room, after everything, it mattered more than I expected it to. Rebuilding what was left cost real things, months of legal fees, a strain with Nathan that will likely take years to fully repair if it ever does, and a version of easy family closeness I understand. Now I may never fully get back. Don't regret protecting the amendment. I understand, looking back, that the version of me who might have quietly let the challenge proceed, who might have told herself it wasn't worth the conflict days before a wedding, would have been protecting a peace that was never actually fair to protect, built on my grandfather's wishes being quietly erased because they'd become inconvenient. I think often about his note, "Don't let anyone make you feel like you have to earn what's already yours." I understand now he knew, better than I did at the time, exactly what kind of pressure I'd eventually be standing under. Brooke's wedding happened on schedule, 6 days after that mediation room, and 2 days before it, she called me herself, not through the group chat, not through our mother, and asked, plainly, if I would please come and stand up front with her the way we'd always planned before any of this started. "This is my day," she said, "and you're my sister, and I'm done letting anyone else decide what that word means." My mother didn't argue when I arrived. She hugged me stiffly at the reception, said quietly, "I'm glad you're here," and it wasn't everything, but it was something true, said out loud in front of people, for the first time in longer than I could remember. It's been almost a year now. The orchard is still ours, still standing, 60 acres exactly where Gerald left them, cider press still older than my mother. I run it now, full-time, the way he asked me to in his own handwriting. Nathan works alongside me these days, in a smaller, more honest role than the one he once imagined, and we're rebuilding something slower and more careful than what we had before. There's a young apple tree near the farm stand that Gerald planted the September I turned 1, The year the adoption finalized, a fact I only learned last spring going through the last box of his old records. A small, faded note in his ledger reading, "Planted for Josie, welcome home." I didn't know, all those years running past it as a kid, that it had ever been for me specifically. I know now. My mother comes by most Sunday mornings now, mostly to help at the farm stand, mostly quiet, still learning how to be a person who says things plainly, instead of managing how they land. Last month she asked if she could bring a friend from her book club to see Josie's orchard, and I noticed she didn't correct herself or soften it into the family orchard the way she might have a year earlier. It's a small thing. I've learned, this past year, that most of the honest things in a family arrive small, one Sunday at a time, long after the version of you who needed the grand gesture has already learned to stop waiting for one. That's my story. One cruel text, one forged affidavit, and an orchard finally being run exactly the way the man who built it always intended. If this reminded you that family was never really about blood alone, take that as your sign today. Share it with someone who's ever been told they didn't quite count. Drop a comment, hit subscribe, and I'll see you in the next one.